Hello, everyone. Thank you for joining us. We'll go ahead and get started. Today is the final part of the Fair Housing and Tenant Rights training. Today, we're focusing on part 3 of the series, which covers the overview of the eviction process. We're very lucky today to have Darlene, Anna, Laura, and Sarah from Bay Area Legal Aid with us, providing this training. And just to introduce myself, my name is Sadaka. I'm a policy analyst at Homebase. And Homebase is a nonprofit technical assistance provider. We provide TA for CoCs across the nation. We work really closely with Office of Supportive Housing in Santa Clara County. One of the many things we do is put on trainings on behalf of OSH, including the Fair Housing and Tenant Rights training series that you're a part of today. And just for some Zoom housekeeping, just to get everyone familiar too, we would like you all to put your name, organization, and if you are a coffee or tea person into the chat just to get familiar with Zoom. We're going to keep everyone on mute by default, but there will be questions at the end for you to unmute yourself. In the meantime, please ask questions in the chat. Also, I will be monitoring the chat as well as folks in Bay Area Legal Aid to help provide answers. And if you have any tech issues, please chat me directly so I can help with that. If you get kicked out of Zoom completely or otherwise unable to chat me, please send me an email at sadaka@homebasecc.org, and I will assist you with that. Also, closed captions are available, so if you hit the closed captioning, you should be able to see them. And I'm going to pass it along to Bay Area Legal Aid. Can everyone see my screen or no?
No.
Not yet.
Okay, let's see. If it shares now. How about now?
There we go.
And I'll pass it on to Bay Area Legal Aid so they can all introduce themselves.
All right. We're Bay Area Legal Aid. We're going to do an overview of the eviction process today. This is the third part of our series. My name is Anna. I'm a housing attorney at our Santa Clara office. Laura, Sarah, do you want to introduce yourselves?
Hey again, everybody. I'm sure lots of you were here for the last 2 weeks, but we'll introduce ourselves again. I'm Sarah, master. I'm an attorney with Bay Area Legal Aid in our housing unit in Office of Law.
And hi, good morning, everyone. My name is Laura Verwer. I'm a supervising attorney at Bay Area Legal Aid in our Santa Clara County regional office in our housing unit. Pass it back to Anna.
Hello, I'm Refugio Wieser. I'm a legal advocate in Bay Area Legal Aid.
And good morning, I'm Darlene Williamson, and I'm a housing attorney at our Santa Clara office with Bay Legal.
Good morning. Oh, sorry.
No, go right ahead.
Sorry. I think we're going to go on to the next slide, or did someone have a question? I'm confused.
I think someone just came off mute. We can move.
Oh, I see. Okay. I'm just going to move forward with our agenda then. We're going to do a real quick overview of Bay Area Legal Aid services. And then we're going to go into the various aspects of the eviction process in California, legal bases for eviction and permissible types of notices, how to read a summons and complaint, how to fill out an answer, how to prepare for a trial, basics of how to negotiate a settlement, and what happens after a trial. Next slide. So Bay Area Legal Aid, I'm sure most of you know at this point, We provide free legal services to eligible persons in the 7 Bay Area counties. We practice housing preservation law, so eviction defense and fair housing, immigration law for survivors of DV and sexual assault. We have a health consumer center for questions regarding access to health care and insurance issues. We have a domestic violence and sexual assault prevention practice that works with our immigration practice. We have an economic justice program that helps people access or retain access to public benefits such as general assistance, CalWORKs, etc. We have consumer law practice that focuses on debtors' rights and fair credit reporting issues, and we have a youth justice project. Next slide. To be eligible for Bay Legal Services, you have to live in one of the 7 counties that we operate in. You must be a citizen or an eligible immigrant. You don't necessarily have to be a documented immigrant, but it's a little bit of a, they would just have to call and we would assess if they're eligible at the point of intake. In general, people trying to get assistance from Bay Area Legal Aid have to have income under 200% of the federal poverty line, but our healthcare line and health consumer center does not have that limitation. In any case, we always recommend if people aren't sure, because who is sure, right? I don't know offhand what the federal poverty line is for a family of 1, 2, 3, or 4. Just call our legal advice line, and again, we'll assess at intake. Next slide. And to access our services, people can call our legal advice line. The contact information is here, or our health consumer center. And on to the substance. Next slide.
Okay, so the first substantive area we'll get into is just a big picture eviction process overview. So Anna and Lara and I will go into more detail as the presentation goes on, but we want to start folks off with, again, just that big picture of what does it mean to go through this eviction unlawful detainer process. Next slide. So this is a kind of timeline of start to finish, how a landlord might start an eviction and what that looks like for a tenant throughout the court process. So the first stage of the eviction is the tenant getting a written notice terminating their tenancy. This usually looks like a 3-day notice to pay or quit. It can be a 10-day notice, 15-day, 30, 60, 90, all sorts of notices, but it's something in writing saying, tenant, you either need to do something or fix something in a given time frame or leave, or if a tenant is living in a unit that's not covered by just cause protections, it might just be you have 30 days to leave, 60 days, 90 days. But that is the first part. So once a tenant gets this notice and the notice expires without them doing whatever is in said notice, a landlord can now file an unlawful detainer or eviction action. We see lots of tenants who are in that first stage, the notice stage, thinking that this means they are getting evicted right then when the notice expires. And so it's good to have this background of knowing that this is just the start of, I don't want to call it long because in legal terms it is relatively quick, but it's the start of a court process. So in tab 2 here, the unlawful detainer action, once the notice expires, a landlord files their complaint. So this lists out what the landlord says the tenant did to need to be evicted. So again, most often, especially lately since COVID, the majority of evictions have to do with non-payment of rent. So the complaint lays out what they say the tenant owes and why the court should grant a judgment in favor of the landlord. Just filing that paperwork with the court does not trigger a time for a tenant to file a response. First, they need to be served. Served means you get a copy of what the landlord filed. And so a landlord might choose to do this with a process server, just anyone, but they themselves can't hand the paperwork to a tenant. A tenant can be served many different ways. They can be given paperwork personally. They can be mailed paperwork, post on their door, all different types of service that we'll talk about later. But they do need to be actually given the court paperwork before it triggers their timeline to respond. In unlawful detainer actions, the timeline is very quick. So if you're familiar with at all with other types of law, other types of legal cases, usually the time frame to respond to a complaint is something like 30 days or longer. In eviction actions, it's 5. So a very quick time frame for a tenant to get all of this paperwork, read through it, understand it, and file a response with the court. If you have someone who's been served with paperwork, please, the second they get it or the second you learn about that, learn that they were served, send them to legal aid, legal resources, the self-help center, anything to help them quickly read through what they've been served with and hopefully file some kind of response. When and if a tenant does respond to the eviction, it is now back in the landlord's court to move things forward. And they do this by requesting that the case be set for trial. It's on the landlord to do this, to request this. And once they do make that request, typically trial is set within about 3 weeks. So again, if we're thinking big picture, start to finish, this might look like a couple months. If the original notice was a 30-day notice, the landlord has to wait for that to expire. Tenant then has time to respond. Landlord has to file a request to set for trial. It then gets set. All said and done, usually a couple months have gone by from that first written notice before a tenant might find themselves in court for their trial. Next slide. What I want to note is that self-help evictions are illegal. Self-help evictions are when a landlord on their own, without filing an eviction with the court, decides to change the locks, turn off the utilities, stop a tenant from accessing their unit. All of this is illegal. So very important if you are working with tenants or even housing providers to just know that this is not the proper process. And if you have a tenant who maybe is in that first stage of just getting a written notice, being able to give them maybe some peace of mind that their landlord cannot, at the end of the 3-day notice or whatever the period is, come in and change their locks. If a landlord does do these type of self-help evictions, there are both civil and criminal penalties. So very important for a landlord to go through the formal court process, go to trial, get an eviction judgment, and then only after all of that has happened is there a notice to vacate by the sheriff. So again, still not the landlord coming in and changing the locks. It's a very formal process. Next slide. So this is, again, a more detailed start to finish overview of that whole court process. So I'll go into a little bit more detail. I think most, if not maybe any of you, are attorneys, so this can be very complicated. But since we're all working in the housing area, just to give you some familiarity with what's happening when a tenant is getting served and going to court. So at the very top, we start with that written notice. And like I mentioned, it can be 3 days up to 90 days or anything in between. Any of that written notices can start an unlawful detainer eviction action. This notice does need to be in writing. It can't be an email, it can't be verbal, it can't be a text. It's a piece of paper that the tenant's going to get that explains why they are being evicted. If a landlord files their unlawful detainer complaint, which is step 2, before that notice period expires, a tenant is going to have a defense to that eviction, and the landlord will likely need to start over. So they do have whatever period it says in the notice to have a little bit of breathing room, knowing that an eviction can't be filed or shouldn't be filed until that notice expires. So step 2, summons a complaint. This is what the landlord is filing with the court. This is going to be usually something that's 20, 30, 40, 50 pages long. And so a lot of times, once a landlord files an eviction with the court sends a notice to the tenant, to whoever lives at that unit, saying, an eviction has been filed against you, here are some resources. Many times we get tenants coming to us saying, I've been served, I got this notice from the court. And so just to know that service of this eviction is getting the paperwork from the landlord that's going to be many, many pages long. Again, 30, 40, 50 pages long. Not the 1 or 2 page letter from the court, just letting them know an eviction's been filed. So once a tenant is served with that big packet of paperwork, they have to file some kind of response. We say answer because that's usually what someone is filing, just an answer of here are my defenses, here's why I shouldn't be evicted. But you also, as a tenant, can file motions. So if the complaint is faulty, if it has defects, if the notice was inaccurate, the tenant might be able to file something, a motion with the court to get the whole case potentially dismissed before it even gets to the point of a trial. This is where an attorney would usually need to step in, but sometimes the self-help center can help identify what motions a tenant might be able to file. But good if in this period you can seek some legal help to really figure out what kind of defenses or possible motions a tenant might be able to file. I'm going to start with the left column first, which is if a tenant does respond. Let's say they do, they file some kind of response. Again, a landlord needs to now request the case be set for trial. There can be a big period of time between when a tenant files an answer and when a landlord requests to set for trial. If a tenant can, throughout this period, kind of start making plans as if things are going to move very quickly, and then can fall back on if the landlord takes a while to request a set for trial, then they've been granted a little bit more time than they were expecting. But it's always best to assume a landlord is going to file this request right away, and that trial will be set relatively quickly. And maybe you get a little bit more time, but again, the assumption should be that it's going to move relatively quickly. After the landlord files that request with the court, the tenant needs to wait for a notice from the court with their trial date. Unfortunately, we see a lot of folks who file their answers, which is great. They, preserve their right to raise these defenses. However, then they don't check their mail or don't know when the trial date is set and then don't appear. As you'll see on the right-hand column, if they don't file an answer or they don't appear at trial, they will get a default judgment against them, which is essentially just the landlord wins. And the tenant isn't going to be able to raise any defenses that they might have or reach a settlement with the court. So really important, if you're working with tenants who have filed their answer, that is the first step. They still need to be on the lookout for a notice from the court, and they still need to appear at that trial date. If for some reason they are unable to appear or they know they're not going to be able to beforehand, they're in the hospital, if something comes up, they need to be able to let the court know beforehand and as soon afterwards, because there will be a default judgment against them. The court is not going to just continue the trial date because you're going to be out of town. So really important to move whatever your tenant might have during that day and appear in court at that time. The folks on this call who maybe deal regularly with tenants who are going to court might know that the time for trial has gotten a little sooner, a little earlier in the morning. It used to be 9 and really it wouldn't start until like 9:30. Now it is 8:45. So again, if you're working with tenants who are getting evicted, you really want to stress getting there on time. Even if they show up at the courthouse at their trial date at 9 o'clock, it's possible that their case might have been called already. And then it's a big headache to try and fix that. So get there early, get there on time, and make sure you're showing up for your trial date to preserve your rights. If the parties at trial are unable to settle, there will either be, if there is then a trial, judgment for the tenant or judgment for the landlord. If the landlord wins, there's going to be an eviction judgment on the tenant's record. They will then soon get a notice from the sheriff for a date that they need to leave or they'll be locked out. If the tenant wins, they are responsible for paying any back rent that they may owe and then can stay in the unit just as a normal tenant, as if the eviction hadn't happened. I'm going to move on now to the right-hand column of the screen. So going back up to the top, summons the complaint, landlord has filed their complaint with the court. If a tenant does not file a response within that 5-day deadline, a landlord can go in for judgment right away. They go in and request default, it's going to be granted because the tenant hasn't responded. And it's as if you went to trial and lost, except it all happens immediately. And because the timeline to respond is so short, a tenant, if they forget about it for a week, or it just, it's too overwhelming, so they put it aside for a little bit. Once that time to respond passes, they very quickly could have a default judgment against them. And it may be impossible to try and reverse that if there wasn't a good reason. And even if there was, it's very hard to get those default judgments overturned. So really important to file some kind of answer if you're served with an eviction. Once default judgment is entered, similarly to the left-hand column as if you went to trial, it's as if you lost. And so the next step is that a tenant will get a notice on their door. It'll say notice to vacate, and it will have a date and a time. This is when the sheriff will come. They will give you maybe 30 minutes to pack up all of your belongings, and they will change the locks. If a tenant gets a notice to vacate, they do have just kind of a final last thing that they can request from the court, which is a stay of eviction. So in the right-hand column towards the bottom, that turquoise box is explaining a request for a stay. So a stay is, I've had a judgment against me, the sheriff's coming on Monday or Tuesday, whatever day, I need more time. And the request is telling the court why you need more time, and you can ask for about generally up to 40 days. The key piece here in requesting a stay is that the tenant has to have 40 days worth of rent, or however much they're asking for, up front when they make that request. And since many times these evictions have to do with non-payment, many times the tenant doesn't have the money to pay 40 days of rent up front, or even 10 days of rent up front. And so while this is a possibility for tenants to get a little bit more time in their unit if they have nowhere else to go, realistically, we see folks don't have the money to do this. So it is an option if you are dealing with someone who has a notice to vacate, the sheriff is coming, know that they can make this request, but it would require a somewhat significant amount of money up front that they're able to pay the court. And then after that stay expires, or if they don't make one after the notice to vacate date, the sheriff will come and lock out the tenant. Next slide, please. Okay, we'll have our first poll. This is just general, us kind of getting to know who's in our audience poll. But have you ever helped a client complete an answer in response to an eviction filing? And again, this is in legal terms an unlawful detainer complaint. We'll give it a few minutes. Folks are answering fast, so probably just a minute or so. Okay. Give it another couple seconds if anyone else wants to respond. Got a majority saying no, but about 25% of you have helped folks with an answer, which is great. If you're in the no column of not having helped someone before, hopefully this will give you a little bit of an overview and maybe feel more comfortable either sending the tenant in the right direction, or at least having kind of that big picture knowledge of what the next steps might be. Okay, next slide, please.
All right. So now that you have a picture from Sarah of the whole process, top to bottom, I'm going to talk a little bit about legal bases for eviction and therefore things that tenants can do to contest evictions. Even before the lawsuit is filed, you can contest an eviction based on the notice alone, although the landlord may choose to ignore it, depending on their risk aversion. And an eviction lawsuit, unlawful detainer lawsuit, can be defeated if the underlying notice that started the process is defective. So we're going to go over these legitimate bases for eviction notice and eviction lawsuit. Broadly speaking, landlords in California can evict for non-payment of rent, for material violation of lease terms or the rental agreement, for no reason if there is no lease agreement and they're not protected by the Tenant Protection Act, which we'll get into a little later, or end of your lease term. Landlords can terminate a tenancy if the rental property is foreclosed on, or if they allege that the tenant is engaging in criminal activity on property. There are some other reasons as well, but those are the sort of the biggies. Local ordinances. I'm most familiar with the San Jose ordinances, Tenant Protection Ordinance, and the State Tenant Protection Act also provide additional protections, which impose more stringent notice requirements on landlords. Next slide. This is sort of a busy slide. It goes over a bunch of the types of notices landlords can issue / tenants are entitled to. A landlord has to issue the right type of notice for the right amount of time with the right options for the circumstances. So it's good to be familiar with the correct formats. Most commonly used are 3-day notices to pay rent or quit, to cure or quit, or just a notice to quit if the landlord believes or alleges that the tenant has done something unfixable, like engaged in violent activity on the property. If the landlord has if the tenant hasn't done anything wrong, but the landlord still wants to evict, then the landlord is required to give a 30-day or a 60-day notice, depending on how long the tenant has been there. If the tenant has been there for less than a year, then the landlord only has to give a 30-day notice to terminate the tenancy. If it's been more than a year, then the tenant is entitled to a 60-day notice. And then finally, if the landlord is ending a tenancy because the property is being foreclosed on, the tenant is entitled to a 90-day notice to terminate the tenancy. That means 90 days before the landlord can even file the eviction lawsuit. And similarly, if the tenant receives a Section 8 voucher, and this is a case where the tenant hasn't done anything wrong, like failed to pay rent, then the landlord has to give a 90-day notice in that case as well. Next slide. Most tenancies, not all, but most tenancies in California these days are covered by what's called just cause protections. Under the state's Tenant Protection Act, I'm going to briefly review those, the just cause requirements for a legitimate eviction notice and therefore a legitimate eviction lawsuit, because again, familiarity with these requirements can clue you or a tenant that you're helping into when there might be a strong defense to the eviction or lawsuit if the landlord has broken one of these rules. Next slide. The California Tenant Protection Act applies only to covered properties, which is spelled out in the statute, Code Section 1946.2. But broadly speaking, it applies to most apartment complexes, right? And it applies to only when a tenant has lived in a covered property for at least 12 months. At that point, a landlord can only evict a tenant for what's called just cause. Basically, the landlord is no longer permitted to do a no reason eviction. They have to state a reason, and the reason has to be one of the types of reasons enumerated in the statute. Also, it's not as relevant to our presentation today, but the Tenant Protection Act also limits the amount that a landlord can raise the rent in any 12-month period to 5% plus the percentage change in the cost of living, or as a shorthand, no more than 10%. There are two types of just cause bases for eviction under the Tenant Protection Act. They're called at-fault just causes and no-fault just causes. Next slide. So at-fault just causes is where the tenant has done something wrong or is claimed to have done something wrong, like non-payment of rent, violating the lease, criminal activity, etc. And the full list is here on the slide. No fault just causes are, again, the landlord still has to give a reason for terminating the tenancy, and it has to be one of these specific reasons: withdrawing the property from the rental market entirely, complying with a court order to vacate the property, planning to demolish or substantially remodel the property, which has a specific definition, or the owner wants to move in or have an immediate family member move in. In the case of a no-fault termination, the tenant is usually entitled to relocation assistance. The landlord either has to give them 1 month's rent or forgive their last month's rent. Yeah, and just to connect this with sort of the earlier section, the at-fault just cause list, those are all 3-day notice based. Those are all 3-day notices. The no-fault just cause list, those are 30-day or 60-day notices. Okay, next slide. I'm just briefly going to go over a little bit about the San Jose Tenant Protection Ordinance. Again, it's the local ordinance that I'm most familiar with, but if you operate in a different city or county, check your local municipal code or regulations to see if there are tenant protections available to you or people that you work with under that. The San Jose Tenant Protection Ordinance is very similar to the state's Tenant Protection Act. It has its own specific list of just cause terminations. Relocation benefits must be paid when a tenant is being removed from an apartment for no fault terminations. I think it amounts to a little bit more than the state act in terms of how much money tenants get for relocation. And again, it only applies to quote unquote covered units as defined under the San Jose ordinance, which, right, look it up, look up the code section if you need to know the exact definition, but roughly speaking, older apartment complexes are covered by the San Jose Tenant Protection Ordinance. Next slide. All right, quick hypo. Tammy, the tenant, lives in an apartment complex and has been there for 1.5 years. Her landlord told her he intends to substantially remodel the unit. Then he served her a 3-day notice to quit. Can the landlord evict her based on this notice? How many people are in the session right now?
It's about 130.
Okay, thank you. I'll give it another minute. I think we've only got a little less than half of the audience responding. All right, I'm gonna call it. Most people responded no, the landlord cannot evict her with that notice on those facts, and that is correct. If the reason for an eviction is to substantially remodel the unit, the tenant is entitled to a 30 or 60-day notice. The 3-day notice is not adequate. Oh, wait, no, in this case, sorry, it says that she's been here 1.5 years, so it's got to be a 60-day. Next slide. Different hypothetical. Tammy has a Section 8 voucher. She moved into the unit on July 1st, 2018. Her lease expired on June 30th, 2019, but the landlord continued to accept her rent. On July 31st, 2022, the landlord issued a 30-day no-cause notice to terminate the tenancy. So it's just a true or false. Is this a valid notice under these circumstances? All right, I'm gonna give it a few more seconds and then I'm gonna close the poll. Okay, this one was a little more split from everybody. We got almost 30% saying true and about 70% saying false. The answer is false, because Tammy Tenant has, this is not a valid notice. I think we have a follow-up to this on the next slide, so I'm not gonna fully explain that answer. We'll just go to the next slide. So it's the same facts. How much notice should she have received? A, B, or C? She got the right notice. I already told you she didn't, so there shouldn't be any people responding A. She should have gotten a 60-day notice, or she should have gotten a 90-day notice. And then follow up, how much notice should she have gotten if she did not have a Section 8 voucher? Is the poll up? I can't tell if.
No, the poll's not up.
So the poll is freezing on my end. My apologies. Can folks put their answers in the chat? I'm trying to relaunch it.
So, okay. I'm seeing some responses in the chat. Thanks, everybody. Looks like most people are getting it correct. Tammy was entitled to a 90-day notice for no cause termination with the Section 8 voucher. And if she didn't have the voucher, she would be entitled to a 60-day notice. So props. Next slide.
Okay, so now that we had a overview and then more of an in-depth dive on notices, now we're actually getting to the unlawful detainer lawsuit. Scrolling back up, I did see a question in the chat about rent increases. So this is a single family home, owner raises the rent from $2,000 to $4,000, so like a 200% rent increase. Is that legal in Santa Clara County? It depends on the owner and whether the state Tenant Protection Act, those rent cap protections go into play. It depends on whether the owner, if they're a single mom and pop, if they're exempt from the unit, from the Tenant Protection Act. If you have a specific question, definitely reach out to our legal advice line so we can get more into the facts on whether that would be a proper rent increase or not. Even if it is a proper rent increase, the timeline may be different. So if it's over a 10% increase, then a tenant is entitled to a 90-day notice if they're not covered under the tenant, the state rent cap. It wouldn't be covered, it's in San Jose. It wouldn't be covered under the apartment rent ordinance because it's a single family home. Okay, moving on into unlawful detainers. Again, as Sarah mentioned earlier, self-help evictions are illegal, and so the landlord does have to go through the unlawful detainer court process. Unlawful detainer is just the name of the lawsuit for evictions in California. Next slide. So now we're going to get into the steps a defendant or tenant has to take when they are faced with an unlawful detainer action. Step one, which is one of the most important steps, is calculating that deadline to file a response or an answer. In California, these unlawful detainer actions, they're dealing with possession of property. Because they deal with possession of property, they're called summary proceedings. And because of that, they go on the much quicker procedural timeline than a regular civil lawsuit, like Sarah mentioned earlier. So the step one is calculating the deadline to respond. Generally, a tenant has 5 court days to file a response, so that doesn't include weekends or court holidays. Step two is reviewing the unlawful detainer summons and complaint. So what is this unlawful detainer about? What are they alleging in the complaint? And this is really good for a tenant or a defendant to really review each paragraph of the complaint, because when filing or completing their answer, they have to go through, and they may have to go through each paragraph and deny each paragraph as false, or if they don't have any information or belief that any of the allegations in the complaint are true, then they would want to deny that as false as well. So we'll get into that in some later slides as well. Step three is reviewing the notice. So Anna went through an overview of types of notices, what notices are correct notices, what notices can be incorrect. Because that notice is that first step of the unlawful detainer process, and if the notice is incorrect, then that can give a defense to a tenant to the entire unlawful detainer lawsuit and really help them preserve their housing or housing stability, at least for a little while, if a notice is found to be incorrect or if there's any defects in that notice. It also can help a tenant come to a favorable settlement agreement and provide that additional leverage when preparing for trial. Step four is completing the answer and the request for a fee waiver. Right here on the slide, we have completing an answer, but as Sarah mentioned earlier in the general overview, there are other types of responses a tenant can file once served with an unlawful detainer action. The answer is the most common response, but for example, if there is a notice defect, there's a different motion that a tenant can file to try and get the case dismissed. So here, since the most common response is an answer, we'll go over how to fill out an answer, but just know that's not the only response a tenant can file within that 5-day deadline. Step five is serving the document. So the tenant has to serve the document on the landlord or their landlord's attorney. Step six is filing the documents in court. So a tenant should file that answer within that 5-day deadline. They can also file a request for a jury demand. So every tenant or defendant in California has that right to a jury trial. A jury trial can be waived if it's not requested timely. And so we recommend filing that request for a jury trial at the same time as filing your answer. Just saves a trip to the court. And it makes sure that the jury trial is not waived at the outset. A jury trial can help provide a tenant some more leverage in negotiating or coming to a favorable outcome in their case. And then also filing that request for a fee waiver if a tenant may be eligible for a fee waiver. And then step 7 is preparing for court, preparing for the trial date. Next slide, please. So step 1, calculating the deadline to file a response. I know this may be a little bit repetitive, but definitely want to ingrain, if there's anything you want to take away from this, this part of the series is just that 5-day deadline, not including weekends or court holidays to file a response. On the bottom, there's a link to the judicial holidays. So you can go to the court website and see what holidays the court considers as a judicial holiday. It may be different than just regular holidays. For example, Abraham Lincoln's birthday is a court holiday, which is someday in February. When calculating the deadline to respond, first need to find out how a tenant was served. So there's different methods of service. There's personal service, substituted service, or posting and mailing if there's a court order. So personal service is when the process server, the person serving the complaint, the summons and complaint on the defendant, physically hands the stack of court documents. So the summons, the complaint, that 20 to 50 stack of official looking documents. They physically hand that to the defendant. That is personal service. And the defendant has 5 days from that time when they were served to file that response in court. Again, these are court days. You don't count the first day that you're served, but you do count the last day. Another method of service is substituted service. So if a process server can't personally serve the defendant, but they go to the premises and someone over the age of 18 is there, they can leave the documents with that person and then mail a copy as well. With substituted service, service is deemed complete the 10th day after mailing, and then that 5-day deadline, 5-day court day timeline will start. And then lastly, a person or defendant can be served by what's called posting and mailing. So this is where the process server will post the summons and complaint on the door and also mail a copy. But in order for a landlord to be able to serve by posting and mailing, they do have to go and get a court order signed by the judge saying, allowing them to serve by posting and mailing. Generally, the landlord has to provide some sort of declaration saying they've attempted with reasonable diligence to try and personally serve, but they were unable to. So please, court, will you allow us to post and mail? If there is a post and mailing order signed by the judge, then the landlord can serve by posting and mailing. If a tenant wasn't properly served, a response that a defendant can file, it's called a motion to quash. We won't get into that in detail, but just know if a defendant wasn't properly served. So for example, not by personal, substituted, or posting and mailing, or say that it was posted on the door, but the landlord didn't get a court order to do so, then an option would be filing a motion to quash. It's basically telling the court that, hey, the court, you don't have jurisdiction or power to make any binding decision over me because a landlord didn't properly serve. At that time, then a landlord can either, if that motion to quash is granted, a landlord can reserve, or if it's denied, then tenant or defendant has to file that response within 5 days. So how do you calculate the deadline to respond? Again, it's 5 court days. You do not count the first day, but you count the last day. So for example, say I'm a defendant in an unlawful, oh no, you can't hear me anymore, shoot.
I can hear you.
Is this,
We can
okay. Okay, there's someone in the chat saying they can't hear. Please let me know if my audio goes bad, but hopefully you can hear. Okay, great.
Yeah, I can hear you fine, Laura.
Okay, perfect. So for example, say I am a defendant in an unlawful detainer action. I was personally served today, so someone physically handed me the court documents. What is my deadline to respond? So I don't count today, Thursday, the day I was served, but I count Friday as the first day. I don't count the weekends, but then Monday is the second day, Tuesday is the third day, Wednesday is the fourth day, Thursday is the 5th day. So next Thursday is my deadline to file a response in court. Next slide, please. So here is just a poll question. Teresa, tenant, tells you that she was personally handed an unlawful detainer summons and complaint last Sunday, so Sunday, April 21st. When is the last day that Teresa may file her answer / response to the complaint before she is at risk of a default judgment? And give it a little bit so you guys can respond. Wait a few more seconds, get your answers in so we can reach majority. All right, we can close the poll. So the answer is Friday, April 26th. So that is so tomorrow would be the deadline to file a response before she's at risk of receiving a default judgment. Just a note in Santa Clara County, the clerk's office does close at noon on Fridays. It's best to go and check the court website to see the clerk's office hours and when they are open. If generally with Santa Clara County, the clerk's office is open until 3 p.m. Monday through Thursday, and then they close at noon on Fridays. But there is a drop box available until 5 p.m. when the court closes. If a person is their last day to file a response, it's Friday, it's 4:30, they should still try and file it. There's also e-filing options as well that they can try to file it. But I suggest, especially if a person is self-represented, that they try to file when the clerk's office is open, just to make sure that they get that confirmation that their answer or their response was accepted by the court. Next slide. So this is just a copy of the first page of our answer packet. We have a pretty detailed answer packet, and please feel free to share our answer packet with anyone who is at risk of eviction or has received an unlawful detainer action. It has helpful information on how to fill out an answer packet, what to look for, and any defenses that they can put in their answer, as well as those blank forms to be able to use to file their answer. Next slide. So step two is reviewing the unlawful detainer summons and complaints. So want to review the summons and complaint thoroughly because it will help in when it's time to fill out the answer. Some things to look for are the case number that will be on the summons and complaint, the name and the address of the court. So if it's in Santa Clara County, then the downtown Superior Court. And also the plaintiff, or if they're represented, the landlord is represented by an attorney, the plaintiff's attorney and contact information. You can also look through the complaint and see basically what the complaint is requesting, either in the form of damages. It's good to see what the complaint is alleging, like how they served a notice, when the notice expired, what kind of notice they served, if they're subject to a local ordinance, or if the Tenant Protection Act applies, or if they're stating that they're exempt from the Tenant Protection Act. Those are all things that will be that may be listed in the summons and complaint. Again, it's really important to review the complaint because a tenant, when filing the answer, when we'll get to in the next slides, they may have to review every paragraph and either deny that allegation. If any allegation is not denied, then the court will deem that can deem that as admitted, that the defendant admits that allegation, and so the landlord wouldn't need to prove that if the case does go to trial. Next slide, please. Step 3 is reviewing the notice. So as Anna mentioned earlier, the different types of notices. Here is where you want to take a fine-tooth comb and look over that notice and see whether there are any defects. If there's a defective notice, that notice is not proper, a landlord cannot proceed with an eviction action, or they cannot prevail in an unlawful detainer if the notice is defective. Again, with the, because this is such a short and quick process in comparison to general civil lawsuits, landlords do have to strictly comply with all statutory requirements, and that includes notice requirements. And if a landlord doesn't comply with all those notice requirements, and there's often sometimes, notice defects that you can find, rules have become a little bit more complicated. And then a landlord does have to start that process all over And finding those notice defects can help to preserve some sort of a little bit of housing stability, or at least provide some leverage when a tenant is negotiating a settlement, for example. So some things to look for is the notice even attached to the complaint? If the notice isn't attached to the complaint, which that is a requirement, then a tenant can file, instead of filing an answer, they can file what's called a demur. Basically, it's a motion attacking the complaint because there's no notice attached. The court can't allow the plaintiff to amend the complaint and include a notice, but if the landlord never amends the complaint and includes that notice, then the case should be dismissed. So step one, is there a notice? If not, that can be cause for dismissal. Next is a notice for the right amount of time. So there's different timelines for different notices. If a landlord provides the wrong notice, for example, it's a Section 8 voucher holder, they didn't provide that 90-day notice, then that's a reason why the notice is defective. Again, you want to look for those defects in that notice to try and get as many defenses as possible. Next slide. Now, step 4, completing the answer and the fee waiver. So the first part, we'll go ahead and talk about completing the answer. Make sure the summons and complaint is next to you when completing the answer or in front of you, because we'll need to reference the complaint when completing the answer. Just a plug for our answer packet, our self-help answer packet. It does have an explanation of affirmative defenses. It's best for a tenant to mark as many affirmative defenses that apply or any objections or defenses that apply to the case. The more defenses there are, the more leverage a tenant has, and the more likely a tenant can come to a favorable outcome in their case. Next, all named defendants must answer in an unlawful detainer. So if someone was served, if they're named in the summons and complaint, they need to answer. If they don't answer, they are at risk at default. So if there's 3 defendants that are named, 2 of them answer, 1 of them didn't, then the landlord can request default against that 1 defendant that didn't answer. So they can all sign on. There's 3 lines on an answer form, the Judicial Council answer form. There's 3 spots for 3 different defendants. If all defendants have the same defenses, great, they can all sign on to that one answer. If they don't, it's probably best to have separate answers so that they can include defenses that would apply specifically to them. Defendant can make 3 copies of the answer. It's best to keep a copy for themselves, 1 for the court, and 1 for the opposing counsel that they do need to serve their answer on. Next slide. And now I'm going to post a link to the Judicial Council form. It's called UD 105. I'll put the link in the chat. It'd be great if you have any questions, or you can pull it up and kind of follow along, because we'll be going over different portions of the answer and different paragraphs of the answer. So I put the link in the chat. It's to the court website, the UD 105 answer form. And feel free to kind of follow along to see kind of what I'm referencing. So in completing the answer, paragraph 1 is just the defendant. So the defendant lists their name. It's best for a defendant to list and spell their name as stated in the complaint. If the name is not spelled as stated in the complaint, it could be a reason that the clerk rejects the answer. If a clerk rejects the answer, then it's as if no answer was filed, and a landlord can request default if a defendant doesn't get an answer filed before that deadline, where a landlord can then request the default judgment. That's why it's also best to go in person as well, especially for self-represented litigants. If they can file their answer in person at the clerk's office, If there's some kind of issue with how they list their name in their answer and it's different from the complaint, the defendant can go ahead and fix it right there. The clerk will let them know, and then the clerk can file it. But if a person uses the drop box at the clerk's office and then they get a court rejection letter via the mail, it can cause problems where default can enter before they were able to fix the issue and have an answer on file. Next, paragraph 2 is about general denials versus specific denials. And this paragraph is important. Paragraph 2 regarding the denials is important because a landlord has to prove every element for an unlawful detainer at trial, in which they allege in their complaint. If a defendant doesn't deny anything in their answer to the complaint, then a landlord can take their answer, the defendant's answer, and say, look, they didn't deny anything. All our allegations in the complaint have to be deemed as true, and therefore we are entitled to judgment because the defendant didn't deny anything. So paragraph 2 is very important on making sure that a defendant does deny the allegations in the complaint. There's 2 different kinds of denials. There's general denials and specific denials. So for general denials, if the complaint asks damages less than $1,000, this could probably more frequently seen in those with subsidies or if they have a housing choice voucher where their rent is really low. Maybe their rent portion was $200 and they missed 1 month's rent, and the landlord then served a 30-day notice and then filed the unlawful detainer immediately. Damages can be less than $1,000 from the date of the notice. And then that defendant can just check the box to a general denials. They're done with the denials. It can move on to paragraph 3 of the answer. In Santa Clara County, rents are very high, so it's very more likely than not that the complaint will demand more than $1,000. If a complaint demands more than $1,000, the defendant does have to go in and list specific denials. So specific denials is the defendant has to go through each paragraph of the complaint, and they can deny as false, or if they don't have any information or belief that it's true, they can deny it as false. It's best to deny as much as possible so that the landlord does have to prove all the allegations in their complaint if the case goes to trial. Again, any allegation that's not denied can later be deemed as admitted, and the plaintiff wouldn't have to prove that that allegation in their complaint at trial. Next slide. So again, we're still in step 4, completing the answer, but now we're moving on to paragraph 3. So this is the affirmative defenses and objections. It is best for a tenant to check off as many affirmative defenses and objections as possible. This is kind of the meat of the answer, telling the court why, even if a landlord was able to prove the elements of the cause of action for unlawful detainer. So one, that there's a landlord-tenant relationship, that they served a notice, and after the notice, the tenant is still there. Even if the landlord's able to prove that, if a tenant is able to prove one of their affirmative defenses, then that can help defeat the unlawful detainer. So there's different affirmative defenses. Common affirmative defenses for non-payment are the first 3 listed here. So breach of warranty of habitability, repair and deduct, or if the tenant paid rent before the notice to quit expired. So these all apply to non-payment of rent cases. For breach of warranty of habitability, the argument is that the landlord is not entitled to demand or collect rent because they fail to make repairs after the tenant notified them of the issues in the unit. Also, if the tenant made any repairs themselves and they paid out of pocket for those costs, and they're being sued for unlawful detainer for non-payment of rent, it's best to just check the box repair and deduct as well. to try and make that defense to the unlawful detainer action. Other affirmative defenses include if the plaintiff demanded rent more than a year old. Landlords are only allowed to file unlawful detainer actions if the rent became due when they served the notice wasn't over a year old, not more than 12 months. Another defense can be waive, change, or cancel the notice to quit. The notice, if it's defective, can be self-canceling. If the landlord acted as if they waived the notice, then that can be a defense as well. Retaliation can be a common defense. So if a landlord made complaints about habitability, maybe they contacted code enforcement and then the landlord served them an eviction notice, that can be an affirmative defense. Discrimination. So in last week's presentation, we talked about a lot of fair housing. If they feel like they're being discriminated against, and that's the reason for the eviction action, that can be an affirmative defense for unlawful detainer. Other defenses are if the landlord failed to comply with just cause requirements. So there's not a valid just cause listed in the notice, or if the plaintiff accepted rent after the notice expired. So the notice expired, but then the tenant paid rent, then the landlord can't move forward with an unlawful detainer action because they accepted rent from the tenant, basically showing that the tenancy continued. Other protections are domestic violence protections, VAWA protections, as we mentioned in our first part of the housing series. Also protections for contacting emergency services. So if the landlord is trying to evict because the tenant contacted emergency services, that's a valid defense. Failure to accept rent from rental assistance or a third-party payment. Also failure to comply with the CARES Act. So this is for federal, for certain covered properties, so properties that participate in a federal housing program, or if they have a federally backed mortgage loan, then the landlords must provide a 30-day notice to quit. Failure to do that is a defense to an unlawful detainer action. And as discussed in last week's presentation, reasonable accommodations can be used as an affirmative defense. And reasonable accommodations can be made at any time, including during the unlawful detainer process, and can be actually put in the answer as well. Next slide. So now this is kind of going towards the last pages of the answer. Paragraph 4 is any other statements. If the tenant vacated the unit, they'd want to specify the date that they vacated in the unit, because the unlawful detainer is about possession of property. The landlord files it because they want possession of the property back. If the tenant surrendered possession and gave the keys back to the landlord, then there's no reason why an unlawful detainer needs to proceed. At trial, the case can be converted to a regular civil action, which would give a defendant an opportunity to file a cross complaint, but it's moved out of the unlawful detainer calendar. That quick deadline doesn't apply anymore, and it's converted to a regular civil action. Sometimes landlords don't want to move forward with regular civil action, so they just dismiss the unlawful detainer complaint.
Can
Also
I just
assert whether
been really quick on paragraph 4. Lara's already specified this, but I just want to highlight a lot of times tenants will just leave after maybe getting served with an eviction or even prior to an eviction being filed. But if you are named in an eviction and you know about it, anyone named needs to file an answer and, like Lara said, specify that they vacated. And if they don't do that, if they don't file an answer and to say, I'm already gone, the court should know that. It's possible they might get a default judgment against them without even knowing about it. So still affecting their credit, still affecting their ability to find other housing. So if you have a tenant who's moved but gets any kind of notification that something has been filed against them, they do need to still file an answer. That's still really important. And again, all you're saying is, I vacated, great, that's all the eviction is about. But please, please, please have your tenants file answers if they know that something's been filed against them, even if they're not there anymore.
Thank you. And then there was something in the chat about VAWA. Want to refer back to our first part of the series where we went over DV protections, including VAWA protection. So please feel free to refer back to the first part of this training series that kind of goes more in depth on VAWA protections. Next, paragraph 5. So what defendant requests in the entire unlawful detainer, they can request reasonable attorney fees if they have an attorney, costs, that the plaintiff be ordered to make repairs. There's also a box where they can add any other requests. It's also good to include just a catch-all request of any other relief the court deems just and proper. So to provide that catch-all that the court can make any other relief they deem necessary. And then lastly are the signatures. So the defendant signs in 2 places. There's the first part where they're attesting to whether or not they use an unlawful detainer assistant for compensation. If they did not, they can just say did not, but then they do have to sign. And then the last part is a verification. So it's the declaration under penalty of perjury that everything they put in their answer is accurate and correct. So there's 2 places that a defendant needs to sign. It's sometimes they sign that first part, but they don't sign the verification. They need to make sure that they sign that verification at the very bottom. Next slide. Now we'll go into the hypo. So the complaint is demanding past due rent in the amount of $3,000. Can defendant check box 2A denying each statement? So this is just that general denial. Can they check that box 2A and move on to the next part of filling out the answer? If the hypo is not working, please feel free to type your answers into the chat. So yes or no. Thank you for typing your answers in the chat. Seeing a lot of no's. And yeah, so those are correct. Oh, here we have the hypo. Yeah, so the answer is no. Again, the defendant can only check that box 2A if the complaint is demanding less than $1,000. But if it's demanding more, then they have to go through and do the specific denials and list each paragraph they deny is false. Or if they don't have any information or belief that that paragraph in the complaint is true, they can deny as false as well. The defendant wants to deny as much as possible. Next slide. And then true or false. There is only one place on the answer where the defendant needs to sign. Okay, we'll go ahead and end it. Getting answers in. Majority say false, and that is correct because there are 2 places where a defendant needs to sign. That first part, whether or not they use an unlawful detainer assistant for compensation. And then next, the verification. So the verification, I would argue, is the most important part. The last place on the answer where they need to sign, verifying everything that they asserted in their answer is true under penalty of perjury. So also the defendant wants to make sure that everything in the answer is accurate and correct because of that verification at the bottom. All right, next slide.
Okay, so we have been talking for a long time and I know we're running out of time, so I will try and go quickly. This is a lot of information to throw at you guys. So if you come up with answers after the presentation is over, like always, feel free to reach out to us and happy to answer those offline. Going off of what Laura is just talking about, completing the answer, the next step, kind of along with your answer, is that most likely, or more often than not, at least we see in our practice, that a tenant will qualify for a fee waiver. So low-income persons may be eligible for a fee waiver, and that means when they file their answer, they file their first response, they don't have to pay hundreds of dollars to the court just to assert their defenses in an eviction. The fee waiver form is, I hesitate to say self-explanatory because all court forms are confusing, but if you work top to bottom, maybe with the help of the self-help center or a friend or legal aid, hopefully a tenant can work through that fee waiver form. But a good way is, as you folks in the audience maybe working with tenants could just get an idea of whether or not your client qualifies for a fee waiver, is just, do they receive any government benefits? So this is things like CalFresh, SSI, Medi-Cal. If they do, they qualify for a fee waiver. They also don't have to fill out the whole form, which is great. There's going to be 3 different steps. And if they, in step 1, can say, I receive a government benefit, and it lists out, check this box, check Medi-Cal, check SSI, then you can confidently know, as the tenant or the person filling out this form, that the clerk will grant your fee waiver. You don't have to go to a hearing. They'll either grant it right there in front of you as you file it, or they'll send you an order in the mail saying that it's granted. If you don't receive some kind of government benefit, it's possible that you still qualify for a fee waiver. You just then move down to part 2, which is just income-based. So it lists out on the fee waiver form if you have a household of 1, 2, 3, 4, and then the income limits. And if you fall under the income limit that's listed on the form, then great, you also qualify for a fee waiver. If you are over that income limit, but you still can't afford to file your answer, there is a third part where you tell the court all of your expenses, all of your income, and it's then up to a judge to decide whether or not to grant your fee waiver. Both part 2 and part 3, those, step 2, step 3, you will have to fill out more of a budget, and the form itself tells you what parts to fill out. But ultimately, regardless of what your income is, if you can't afford to file your answer, you should apply for a fee waiver. If it's denied by the judge, you're given a period of time to then pay for the filing. Next slide, please. Similarly to how a landlord, when they serve a tenant, then has to tell the court, here's my proof of service, a tenant also needs to serve their landlord with their answer. This is often a piece that is forgotten or missed, and it's really important that the tenant does do this. So serving the landlord means mailing a copy of the answer to them. The tenant themselves cannot mail the paperwork, but they can get someone else to. It does not need to be a registered process server or the sheriff. It can be a friend, a family member. It needs to be someone who is not named in the paperwork, and it needs to be someone who's over 18. There's a proof of service form. It's listed on the slide here, the POS-030. This is a proof of service form. Again, start at the top, work your way down, filling out the form as it tells you to. Seek help if you're not sure how to fill out the form. But the main things that I want to note here is that it cannot be the tenant who mails it. It cannot be someone who's named on the paperwork. If you are a case manager, you are able to mail this for a tenant. We as attorneys can mail proofs of service for our clients. It's just the person listed on the form that can't do that. They need to serve the paperwork, again, putting that in the mail, and then file that proof of service form with the court. The filing does not need to happen the same day, but they should immediately mail the paperwork once they've finalized their answer and signed it. Next slide, please. A lot of poll questions today. Another poll question. Who can serve the answer on the plaintiffs and fill out the proof of service? If the poll doesn't pop up, again, put it in the chat. A, the defendant's child that's under 18. B, the defendant themselves. C, the defendant's child that's over 18 and named in the complaint. Or D, anyone that is not named in the case and over 18. Looks like the poll is up. Okay, hasn't been long, but for the sake of time, I'm going to end our poll. I see lots of D's, which is the right answer. Anyone who's not named in the case and is over 18. So in answer C, that got quite a few folks choosing that answer. The reason C is wrong is because the defendant's child was named in the complaint. So no one named. If you have a family and only one person for some reason was named, the other family members could provide service. However, if they are named in the complaint, they cannot. Next slide, please. So you've filled out your answer, you signed it, you filled out the fee waiver, you've signed it. You need to file this with the court. So another step we do not want folks to miss. Just because you've signed it does not mean the court knows about it. So really important, like Laura said, is to go and file your documents with the court. There is a Dropbox, but for all the reasons Laura said, it can be scary if you don't have someone in front of you saying your answer has been accepted, because many, many times we have answers rejected because of small errors that maybe they shouldn't even be rejected, but they are. And the consequences are very bad for tenants if an answer is rejected, even for an incorrect reason. And this can be as small as they spelled their name the way it should be spelled, but different than what it says in the complaint. So best, if possible, to go to the clerk's window and file that in person. Get a copy from the clerk. They're not going to just automatically offer you a copy, ask for a copy, especially just to keep for your records, but also if you didn't make one yourself, so that you can serve your landlord with that copy. Just a reminder to check the clerk hours. Sometimes they vary, but oftentimes they're not open late in the afternoon and sometimes even close as early as noon. So if your last day is Friday and you think, great, I have all day, you don't actually, which is unfortunate. If the clerk's window is closed and it's Friday, it may be too late, even though you're ready and willing to file your answer at 3. So the earlier, the better. Next slide. Okay, you file your answer, you file all your paperwork, everything is accepted. Great. Your next step is to prepare for your trial. So once you filed your answer, you're going to get a notice from the court. It's going to be like a 1 or 2 page letter that gets mailed to you that tells you your court date. You show up at court at this date and time, hopefully early to account for parking, and you will have potentially a trial on this day. So the tenant should go into this date not thinking that they automatically are going to settle, or that if they don't settle, they'll have more time to prepare. The tenant should bring any evidence that they have to support their defenses or any witnesses that they may have to this trial date. Many cases do settle, and so you might have witnesses that you brought with you that are just gonna kind of twiddle their thumbs in the courthouse, but better to be prepared versus not. At a minimum, bring the physical evidence that you want, the paperwork that might, show you did try and pay your rent, whatever it is, bring that to court for your trial date as you prepare for your trial. If your case is set in 3 weeks, that's not a lot of time to gather evidence, especially if you weren't represented during this time. You don't have someone requesting discovery, which is evidence from the landlord, and so you might not have a lot to bring with you. But anything that you do have, take it to court with you. If it's stuff that's on your phone, or if you have clients, your tenants, that they have things on their phone, try and print these things out so you're not just showing your phone to the judge saying, here's my proof. Anything that you do want to bring as evidence, make copies of it so you can be handing it to the other side, handing it to the judge. All that to say is just, it's going to be a lot of paperwork that you're taking with you that hopefully you don't need, but better to be prepared in case it does proceed to trial. At any point during this process, a tenant can be reaching out to legal aid, to the self-help center, to anyone. If it's kind of late in the game, we can't guarantee that we're going to step in and represent a tenant, but at the same time, it might be advice that we can provide them, run through their defenses with them and say, in our opinion, maybe this is best to try and settle, or this defense is really strong. And so even if they've got a court date tomorrow, it doesn't hurt to try and reach out and still seek some legal advice prior to that court date. Next slide, please.
All right, we are very nearly out of time, so I'm going to spend like 1 second on my slides here. Sarah was saying, tenants should come to their trial date prepared for a trial, or at least assuming that they may have to do a trial. Yes. That said, most eviction cases where a tenant knows about the process and knows what their options are will end in a negotiated settlement. A landlord or a tenant can make a settlement offer, like waiver of back rent in exchange for a quick move out, or getting to stay if they can pay all of the back rent in, you know, a week or two. Negotiations typically take place in the courtroom, or specifically in the hallway right outside the courtroom while you're waiting for your case to be called. Tenants have to read any proposed settlement agreement carefully because they will be bound by it, right? The terms of a settlement agreement almost always will say, we know what we're signing, and then you sign it. So even if you don't know what you're signing, you're going to be bound by it. So you should definitely try to, you know, Google terms, ask resources in the courtroom for help and advice. If a settlement is not reached, if nobody can agree on anything, then the case will just go to trial. Next slide. This is just a slide of terms to know in trying to negotiate a settlement. I'm not actually going to read through these again because we are basically out of time, but they're useful if you're in the courtroom. Next slide. In Santa Clara Eviction Court, on the day of trial, there are almost always mediators, free mediators in the courtroom, and various rental assistance agencies also in the courtroom. That the tenant, again, should be reaching out to while they're waiting for their case to be called. So tenant walks into the courtroom, checks in with the bailiff, and then goes, hey, where do I find rental assistance? And keep asking until you talk to somebody. Especially if the issue is rental assistance, tenants should try to bring bank statements or pay stubs with them to court to speed up the assessment for eligibility for rental assistance. And next slide. After trial, someone wins and someone loses. If the tenant wins, then the tenant has to pay all of the rent owing in about 5 days. And then their tenancy continues as if nothing happened. If the landlord wins, then the judge issues an order called the writ of execution saying landlord wins, the sheriff is entitled to do a lockout. The sheriff will post a notice on the tenant's door saying, we're the sheriff, we're coming back in 5 or 6 days. We're going to change the locks if you're still here. And that will be the end of the sheriff's lockout, is the end of the tenant's tenancy. Next slide. Tips and tricks: spell names the way they're spelled on the complaint, even if they're not right. Answer even if you think you've missed the deadline. If the tenant isn't sure what's going on, go to the court clerk and ask for a copy of any documents. All right. We have 0 minutes left, but if anyone wants to ask questions, I can hang out for a few minutes to field some questions.
I'm also happy to hang around. So that was a long presentation, and I know, again, kind of complicated material, but if folks do have questions, please feel free to unmute and ask.
I did type in the chat earlier. There just seemed like there's a little bit complex process from when you initially get that, you know, let's say a 3-day notice. They have 5 days to respond to that 3-day notice.
No, that is the time frame. So let's say it's a 3-day notice to pay or quit.
Yes.
In those 3 days, the tenant either pays what's requested in the notice, or if they don't, when the 3 days expires, the landlord can then just file that paperwork with the court. So just start the court process.
Right. So they just have 3 days to either pay or not pay. And by not paying, that's responding that the tenant saying, you know what, I'm not going to pay the money, I don't have it. Then now that gives the right to the landlord to go file in the court proceeding to say, hey, yes, we're going to file this now. And then there's going to be an actual letter that gets mailed from the court to the tenant.
So notice, pay or quit. And if tenant doesn't pay and they don't leave, which is the quitting part, that now allows the landlord to file an eviction. So prior to the 3 days expiring, landlord cannot file an eviction, nothing on tenant's credit, no judgment possibility. They could leave, okay. But if they don't, in that 3-day time, a landlord can now file an eviction, which then starts this court process and potentially would end in a judgment for the tenant. So they should kind of consider that period of the notice as, do I want to try and resolve this before it potentially leads to an eviction? Because if they do nothing, a landlord can file an eviction.
Great, thank you for clarifying that.
It's very confusing.
I know, 'cause then I'm like, okay, now they have 5 days to respond to this notice, but that's
Right,
that's
yeah,
the other notice that's coming from the court. I
The
believe.
court
So,
just gives the
no,
kind of heads up, a case has been filed against you type letter.
Yes.
But the landlord themselves, through a process server or whoever, has to serve the tenant with the eviction before that timeline to respond starts. So that's the tenant getting this big packet of court paperwork. That's when their 5-day timeline starts.
Got it. But that's when that timeline starts, and then the tenant responds by doing the proof of mail, right? Correct? They have to.
they file an
filling out
answer.
Answer or some kind of motion as their response.
And then what is that other thing you guys mentioned about the going to the actual courthouse to,
File their
that also be another way to respond?
That's how they respond. So they fill out their
That's the
answer.
only
They
way to respond.
they
to the
have to
lawsuit.
file it. So just doing it at home and signing it, the court has no idea the tenant's done that. For it to be, you've officially responded, they have to file it with the court. So really important that whatever they fill out needs to be given to the court, filed and accepted, or it's as if it didn't happen. So if they send an answer just to their landlord, but
Yeah.
never file it with the court, they could still get a default judgment against them. and
Got
have
it.
on the record.
So they need to file that with the court. And what's that other thing? They also have to mail their answer to.
Yes.
Mhm.
Similarly to how the landlord has to actually serve the eviction on the tenant before that timeline starts, the tenant has to serve their answer on the landlord. So essentially, everyone knows what's happening. Landlord gives tenant the paperwork, tenant gives landlord their answer, a copy of it, so they know what defenses the tenant is raising. Everyone's on notice of who's filing
Everyone's on the
what.
same page.
Often no, but in theory,
No.
yes.
All right, thank you.
To be clear, like the confusing part for people who haven't, for tenants who don't have legal counsel or haven't encountered an eviction process before, the court does not facilitate any of this, right? It is all on you as the tenant to make all of these communications happen.
Yeah, the court won't reach out and say, hey, your 5 days are ending, or, hey, you didn't file an answer. They'll just say an eviction's been filed against you. Be on the lookout for court paperwork.
And generally to note, just going to like the proof of service, anything that's filed with the court generally also has to be served on the other side. That's where that proof of service comes in, to let the court know, yes, I did inform the other side. The only exception is like fee waivers. Fee waivers do not need to be served on the opposing side. They don't need to know their financial situation. That's just for the court to determine whether or not a fee waiver can be granted or not. Are there any other questions?
No, we're a little past time.
Yeah. Thank you so much, everyone, for engaging and asking your questions. And please provide any feedback to us. We'd love to hear any feedback that you all have.
Thank you, everyone, for attending. And again, thank you, Sarah, Laura, Anna, and Darlene for presenting throughout these sessions, and we really appreciate it. Thank you.
Thanks, everybody.
Wait, I have one more question. Sorry.
No worries.
So you know how we have the VAWA, I know there was a VAWA training, but there's an actual, it's called a lease addendum where we sign for just cause, like the landlord cannot terminate the tenancy for just cause. I don't know if there's been cases where the landlord tries to like find a loophole and they try to evict. Can they still serve, like they're serving a notice, but they really don't have a just cause, or not just, they really shouldn't be, they're just trying to find like a loophole to try to get rid of the tenant.
Landlords do that all the time.
Is that gonna stick in court, or would that stick, or they would just throw it out right away?
No, the court will not throw it out unless the tenant asserts their defenses.
Oh, interesting.
People file bad lawsuits all the time outside of evictions, just across the board legally. So there's nothing that stops the landlord from filing a bogus suit, even if the tenant might have a complete defense, like maybe a VAWA defense or a notice defect or whatever. But that is something that the tenant has to affirmatively raise in a motion and their answer and still go through this court process to eventually, hopefully, get the eviction thrown out. But they absolutely
They have-
still have to file an answer or a motion. And
Got it. Okay, thank you for that clarification. Yeah, because I actually saw that in real life where a landlord actually found out later that the tenant was convicted felony of a crime, whatever the thing was. And then the landlord felt uncomfortable having the tenant there because he was previously a convicted or felon. So they were just trying to find a loophole, like, how do I get this person out? And so they were just trying all kinds of things. I think it eventually did go to court, but I don't know what happened at the end, but.
That sucks. Also, improperly using like criminal background checks is its own. I think that's protected under the Fair Employment and Housing Act, isn't it?
Yeah, and we went over that. But,
right. It
and-
depends. It depends a lot on circumstances and how that would happen. But someone in that circumstance might have a remedy outside of eviction law.
Yeah,
Right.
there's some want to reference part 1. We did go over criminal history protections.
Great. Well, I really appreciate the presentation. You guys did an amazing job, and thank you.
Thank you for your questions.
Thank you.